Ladies and gentlemen, the American Jury and Bulldog Nation, welcome to another edition of Eric Deters, the Law. And I'm excited about this series. And today we're going to cover wills, estates, and trusts. I'm going to give you an overview. This is meant to be educational. I'm a retired attorney. It's not meant to be legal advice, but it's meant to guide you. And if you've got any questions about this type of law, you can email me at eric@ericdeters.com or text me at 859-250-2527, and I'll hook you up with a lawyer that can help you actually do this stuff. I can always give you free advice as long as I don't take any money from you. First off, we're going to begin with power of attorneys. A power of attorney is a document that you sign or somebody signs giving someone else the power of attorney over their affairs. It can be limited. It could be just for their health. It could be to just their finances. It could be just for one real estate transaction. It can be for the sale of the bicycle that you want to sell. I mean, it's all over the place. It can also include more than one person. You can give power of attorney to two people, two children, so they have to agree, three children. It's a written document that has to be properly executed and signed and witnessed and or notarized under the laws of that state. Kentucky, Ohio has different rules, but generally it's prepared by an attorney. It doesn't have to be prepared by an attorney. It has to be signed, has to be witnessed and notarized. But a power of attorney is very important. Let me give you an example, though. This is a big question that comes up. A power of attorney ends upon the person who gave its death. So if I give power of attorney to Josh Wentz here and I die, that power of attorney does not exist anymore. Okay? When I give Josh my power of attorney for finances, that power of attorney, he can go to the banks, handle my banking, handle this, everything else. You've heard all of these, the hospitals will always ask you, do you have a living will? You know, that is kind of like a power of attorney where it's like, hey, who's going to make these last minute decisions? By the way, I oppose those 1,000%. All they are is a pain in the butt, the living will, making these decisions. You know why? There's some exceptions depending on your family dynamics. But do you know what hospitals are going to do if you don't have a living will? They're going to ask the spouse, what do you want to do? If there's no spouse, they're going to ask the kids, what do you want to do? And unless you know there's going to be a war, living wills are just a pain in the butt, useless, in my opinion. Guardianships. Guardianships are a step ahead of power of attorneys in the sense of this. A power of attorney you do willingly. You have to have the wherewithal, the mental ability to sign the power of attorney. Guardianships are different. Guardianships, you go to court. You can get a guardianship over somebody. Let's say I'm completely out of it. I'm just completely out of it. Josh can go to court and get a guardianship over me where he says, hey, man, I've known the Bulldog for a long time. I want to take over his affairs. I'm the best guy to do it. And everybody, the closest heirs are always notified. So you come in and you fight about. My wife would no doubt would say, wait a minute. I know he liked you, Josh, but I'm going to be the guardianship. But you go to court. The same thing with the minors, okay? A minor cannot give a power of attorney. For a minor, you have to go to court and get a guardianship. By the way, on the guardianships, Josh, you'll appreciate this. When you're getting guardianship over somebody, they actually hold a little jury trial in Kentucky. It's a jury of 6. They call them in. They do them like once a month. And it's like a 10-minute trial. It's hysterical. Somebody takes a stand, explains why they want the guardianship. The jury decides that they're not mentally competent to manage their own affairs. But the same thing over minors. You can't set a lawsuit for a minor unless the guardianship is set up and approved and the settlement's approved. Wills. All right, this is the biggie, right? Everybody should have a will. Why should you have a will? You should have a will because then you're deciding how everything goes. If you don't have a will, the state statute, and we're going to get to that later, the state statute will decide how all of your property passes. But you need to have a will. Let me give you an example in a will. You might want to say, I want to give all of my children equal, boom. You might want to say, I want to give all my children something except this child, I do not want to give anything for whatever reason. By the way, you can do that. But if you want to, like, quote unquote, not leave a child something. If you don't have a will, that child's going to get something whether you like it or not. You also have very specific things, okay? Like I got a baseball card collection. I would want my son Parker to have the baseball card collection. If I don't put that in the will, then he may not get it. You can also always change things in a will. And when we're talking about changing a will, we're talking about a codicil. You can just redo the whole will, or you do a codicil. A will has to be executed. It has to be witnessed. There's something called a self-authenticating will, where somebody notarizes the witnesses and everybody else, and you can avoid court in Kentucky. But the bottom line is a will has to be properly executed. Now, this is something that you should know. You can write up your own handwritten will, Josh Wentz. Josh Wentz could sit down and say, I'm not feeling very good. I think I'm going to die today. And he could write down a will, and he could say, I'm going to give the Bulldog all my camera equipment, and everything else goes to my wife. And he can sign that and date that. That is a valid will. A will written like that does not even have to be witnessed. So that's another thing. All right. I'm going to talk about wills some more in a minute. All right, let's talk about trusts. A trust, just like a corporation, is a legal entity. You got to get a tax ID number, and you operate a trust. I've said this to you ever since I was on 700 WLW radio. You should have your home in a trust. That will protect your home from everybody except your property taxes and your mortgage company. But if you ever got sued, you ever have big hospital bills, you're going to be protected. I did that. My first wife died of cancer. I created a trust. If you remember, is a big part of that legal battle that I had with that one lawyer that I don't care for. It drives him freaking nuts because I created a irrevocable trust for two reasons: estate planning purposes and financial liability. If you're a CPA, a doctor, lawyer, an engineer, building could collapse. You need to protect your assets. You're a fool not to have a trust. You should have a trust. What kind of trusts are there? Well, one's called revocable, where you can revoke it at any time. Another one is called irrevocable, where you can't revoke it. The reason why irrevocable is more important than revocable is it affects whether or not somebody can be attacked. For example, somebody can try to attack your trust. There's something called fraudulent transfer. That's what that one Nimrod tried to do on me, proved him completely wrong. But there's all kinds of different trusts. There's something called generation skipping trust, where you skip your kids and go to your grandkids to avoid tax. But there's all kinds of tax issues relative to trusts. And you got to hire a good CPA, good lawyer to handle those tax issues. I'm not going to get into that. The trustee, all right, the person who gives the power up is called the grantor. And the person you give power over to manage the trustee or manage the trust is, by the way, you can put anything in a trust. You can put real estate, you can put your car. We could put these plastic boxes in the trust, is the trustee. And the person who receives the funds is the beneficiary. Normally what a trust is set up is it is set up while you're living, and it's going to be over when you die. Not all the time, but generally it'll die, and the trust gets dissolved and everything passes on to the beneficiaries. There's 1,000 ways to do this. But the trust, the grantor, the trustee, the beneficiaries. Now let's talk about probate. All right. Probate is when everything you got goes through the court system, the probate court. Kentucky, Ohio, every state has a probate court. Do you know how you avoid probate? A trust. If you put everything in a trust, or you give everything away. If you know you're dying of cancer, you can give everything away with that. When my first wife was dying of cancer, we transferred the house to the trust because then it avoided probate. There was never an estate opened up for my wife. I have, just so you know, I have everything of any significance I have in a trust. And guess what that means? That means there may not even need to be a probation of my estate. Let me tell you something that's good about that. Confidentiality. You don't want anybody to know whether you died rich, poor, or otherwise. If you put everything in a trust, you hear about these people that they said they died with no money. You don't know what they gave away. You don't know what they put in a trust. That's not public record. Probate is public record. Trusts aren't public record. I mean, it's that simple. You want to avoid probate because you want to avoid inheritance tax. You want to avoid the court system. You want to avoid all these things. Now, people ask this question. This is a big question asked all the time. Are you responsible for the debts of your parents? No. If your parents die in debt, you don't have to pay their debts. Now, if you set up an estate, there is a time, it's usually 6 months, I think, where anybody who has a claim against that estate has to file their proof of claim with that estate, and the court will decide whether that claim goes forward or not. So if you die with $1 million and you owe St. E's Hospital $2 million, I guarantee you St. E's Hospital is going to file proof of claim against your estate and take all your freaking money. You want to avoid probate at all costs. How you do that with estates? I'm going to talk about estates some more now. An estate is when you die. That's your estate. If you die testate, that's the word that's used. That means you had a will. And the people that are appointed to run that are the executor, if they're male, and executrix, if they're female. I'm surprised the woke crowd hasn't gotten to this yet, Josh Wentz, that there should just be one word, executor, executrix. But that's the estate. The executor and executrix wind up the estate. If you die what's called intestate, that means you didn't have a will. The court will appoint an administrator, if you're a male, or administratrix, if you're a female. You can't make this stuff up. There's also some taxes are the most important thing in all this, folks. You want to avoid tax. You want to avoid state inheritance tax. Kentucky and Ohio has them. You want to avoid federal tax. By the way, just to let you know, when I was in law school, there was only $600,000. I think it got raised up to like $5 million. There is something I haven't talked about yet, that it's called gifting. There's gift taxes too, but you can give, I think it's $5 million now that you can give that's attributable to the exemption, to where you can give away up to $5 million without paying any tax on it, any gift tax. So when you get, that's another issue. Planning. You got to plan, folks. You got to plan. You got to plan. It's that simple. Your heirs. Now, this is really important. This is some fun stuff, okay? Here, most state laws of how things pass say you don't have a will, okay? By the way, even if you have a will and you try to disown your spouse in Kentucky, spouse is going to get 50% no matter what. So it's a statute. You cannot disinherit your spouse. Your spouse is going to get 50% unless you agree otherwise. All right. So here we go. If you die without a will, your 50% goes to your spouse, 50% would go to your children. If you don't have children, it all goes to your spouse. If you don't have spouse, it all goes to your children. Now, if you don't have children and you don't have, then it goes to nieces and nephews. It goes down. When that line is over, so you die and you don't have any children, no nephews or nieces, intestate, here's what happens. It goes back the other way. If your parents are alive, they get it first. If, let's say you die, you have no children, no spouse, no nephews or nieces, no parents, it goes to your brothers and sisters. If you don't have any of those, it goes to the state. Another reason to have a will is to make sure the state doesn't get all your assets. But that's how that works. It's pretty interesting. It gets complicated. Again, you need a lawyer to guide you through these, but I think did a nice job of giving you an overview. And what I gave you is what we call black letter law, generally, for all the states. Again, if you got an issue in this field, email me or text me, and I'll put you in touch with a lawyer that can help you out. This is the Bulldog. Every dog has their day. Have a great one.